This is Duke University.
Okay, good afternoon, everyone. We'll get started in just a moment as the few stragglers are coming in. I'm Larry Helfer, and I'm the co-director of the Center for International and Comparative Law at Duke Law. And I am really quite delighted to have with us, as part of the lecture series that we're doing this year, Professor Rochelle Dreyfuss, who is the Pauline Newman Professor of Law at NYU Law School and also the co-director of the Engelberg Center on Innovation Law and Policy. Rochelle has been one of the leading lights in intellectual property law and also in international intellectual property law for quite a while. She has been writing in particular about the TRIPS agreement over the course of a number of years, different aspects of the TRIPS agreement. She wrote one of the great predictive articles about TRIPS dispute settlement back in the 97, I think it was, 98, the Virginia Journal of International Law. It was such a good article that I had to get a second copy because I underlined the first copy so much that it fell apart. And so what she's going to speak with us about today is her new co-authored book, A Neofederalist Vision of TRIPS, and some of the policy prescriptions that relate to that. And we're also delighted the book is literally hot off the presses, and Professor Dreyfus will be around after the lecture in the loggia, where you will be able to purchase a copy of the book and where she can sign it if you so desire. So I'm delighted that you're all here and to hear this lecture by Professor Dreyfus. So without any further ado, I will turn things over to her. So, welcome.
Thank you. All right, so thanks, Larry, for inviting me here, and also Duke for unofficially launching the book. The official publication date is 2 days from now, and I actually haven't seen the book, so I'm very much looking forward to seeing them in the loggia, do we call it? Yeah. So. The hallway, okay. Anyway, launching here is particularly appropriate because the book examines the state of international intellectual property law, and the bounds of its analysis was essentially set by Larry Helfer on the one hand and Jerry Reichman on the other. So I've very much taken to heart Jerry's skepticism about deep harmonization, about a one-size-fits-all international intellectual property regime. At the same time, Larry Helfer's work on regime shifting has made it clear just how messy international intellectual property law can be when it's made serially by national governments, by regional organizations, by the World Trade Organization, the WTO, by UN agencies, not only the World Intellectual Property Organization, WIPO, but also the World Health Organization, UNCTAD, the Food and Agriculture Organization, the FAO, UNESCO, as well as by other international entities, such as the European Court of Human Rights, by UPOV, the Union for the Protection of New Varieties of Plants, and through the CBD, the Convention on Biological Diversity. For me and my co-author, Graham Dinwoody from Oxford, the axis between the Reichman appreciation for diversity and the Helfer documentation of continual fragmentation cried out for further exploration. So the book starts with the claim, which is made by many economists and trade specialists, that the WTO's trade-related aspects of intellectual property rights agreement, the TRIPS agreement, represents a comprehensive code of international intellectual property law. Following Reichman, we argued that such a view is a normative mistake. A one-size-fits-all code ignores distributive justice concerns, each individual country's other values, cultural policies, technological maturity, all of which domestic lawmakers would certainly take into account in setting the contours of their own intellectual property legislation. Further, we dispute historical and descriptive accounts suggesting that TRIPS was intended as a one-size-fits-all regime. We don't think that those signing on thought that's what they were agreeing to, and the text doesn't reflect that view. So, for example, Articles 7 and 8 of the agreement, entitled Objectives and Principles, talk about balancing interests, about enhancing social and economic welfare, about promoting the public interest. There is also other wiggle room, as Jerry has dubbed it, undefined terms that cry out for individuated treatment, such as the definition of inventive step, requirements that are pitched in flexible terms, such as unjustifiable encumbrance of a trademark or normal exploitation of a copyright, the legitimate interests of patent holders. Most important, we argue, that a code view makes no sense prescriptively. The diversity of creative impulses, talents, skills makes for a rich outpouring of intellectual effort. That productivity should be cherished, not squelched by homogenized law. Further, knowledge is cumulative, so intellectual property law has to deal with the differing ways that different groups of innovators draw upon the works of others. And then there's the problem of historical contingency. Technology changes. If too rigid, TRIPS would soon snap. So our view is of a system where the states are the primary actors, but they cede some sovereign authority on certain substantive matters, things that are trade-related within the minimum standards of TRIPS, and commit to future lawmaking in the WTO through the Council for TRIPS and the General Council of the WTO. Now, of course, there's no central authority in that system, as in a federal government. Rather, there's a commitment to coordinated responses to new problems. And that's why the title of our book is A Neofederalist Vision of TRIPS. Sort of federalist, but not quite. Admittedly, as we show in the second part of the book, panel decisions of the WTO Dispute Settlement Board, the DSB, have not always acknowledged that the room that TRIPS leaves for national lawmaking. Panels have not accepted the textual invitation to adopt a normative vision. They've been unwilling to measure state action against the objectives and principles provisions. They've interpreted the exceptions tests of TRIPS very narrowly. They act in general more like accountants than as custodians of a system that's deeply entwined with culture and with science. Now, admittedly, more recent cases have a somewhat different texture. The appellate body, in reviewing panel decisions, has been more deferential to national choices than the panels, and one of the few accomplishments of the Doha round of negotiations was a ministerial statement also sensitive to diversity concerns. That said, if Larry Helfer is right about regime shifting, winning or losing the argument about the code view of TRIPS could be irrelevant. If the code view is wrong, the demandors of strong protection, those seeking deeper harmonization, will simply take their business elsewhere. And indeed, we've seen that. So there are new multilateral agreements that were negotiated in WIPO, the WCT, the WIPO Copyright Treaty, and the WPPT, the WIPO Performances and Phonograms Treaty. We see the addition of intellectual property rights to old multilateral instruments, such as the Convention on Biological Diversity, the CBD, multilateral soft law initiatives, such as the Joint Recommendation on Well-Known Marks, plurilateral instruments, such as the recently negotiated Anti-Counterfeiting Trade Agreement, ACTA, and regional agreements, such as the currently being negotiated Trans-Pacific Partnership Agreement, the TPP, bilateral free trade agreements, bilateral investment treaties, all of which have intellectual property components in them. These agreements are partly aimed at clarifying existing terms in TRIPS, but mainly they raise the level of protection. For example, TRIPS requires protection against passing off, misuse of a trademark to confuse consumers, but the joint recommendation also requires protection against dilution, tarnishment, and blurring, which have nothing to do with confusing consumers. TRIPS does not deal with digitization on the internet, but the WCT prevents hacking into encrypted files. ACTA would impose secondary liability on certain internet actors. TRIPS is concerned with unauthorized use of protected products within each country's internal market. The TPP would require the seizure of counterfeit goods in transit. So TRIPS plus. But even if the code view were right, we might see the same thing, regime shifting to other institutions to produce counternorms. So hard law, such as WIPO's proposed treaty for the visually impaired, softer initiatives, such as WIPO's development agenda, which claims to promote norm-setting activities that support a robust public domain, and other soft efforts, such as UNCTAD's materials on how to make the most of the compulsory licensing provisions of TRIPS. So either way, people who want stronger protection go regime shifting, people who want lesser protection also go for regime shifting. And the last part of the book, the part I was asked actually to talk about today, deals with this proliferation. So first we ask, is this activity malignant fragmentation or benign regulatory competition? So on the one hand, many questions call for technical answers. What constitutes a national emergency under TRIPS compulsory licensing requirements, whether copying is so widespread that it triggers special rental rights requirements under TRIPS, whether regulatory use of undisclosed data is unfair to branded pharmaceutical companies under the trade secrets part of TRIPS. All of those are questions that have technical answers, and the input from multiple expert bodies would be very useful in trying to decide what these provisions actually mean. But at the same time, intellectual property law is about promoting investment into intellectual efforts, and encouraging disclosure, commercialization, and dissemination. The more risky the legal environment, the less people are willing to invest, or the higher returns they will require. So multiple inputs could also undermine the ultimate goals of intellectual property law, which is to promote the progress of science and the useful arts, as we say here. So one example of that is the addition of rights over genetic resources to the CBD. That's going to create new right holders and erect multiple new barriers to bringing products to market. Or consider the plaintiffs in the recently decided Golan against Holder. These were orchestra conductors, educators, performers, publishers, film archivists, motion picture distributors, who had all invested on building upon works that were already in the public domain. What happened? They lost their investment when the Supreme Court approved an international deal to restore lapsed copyrights in the works that they were building upon. And as Larry Helfer has so ably traced, there are also disputes that cycle amongst national tribunals, regional tribunals, and the WTO. The prospect of moving from tribunal to tribunal and never getting a definitive final judgment just can't possibly be good for encouraging people to make money and intellectual investments in innovation. So for us, the ultimate question is how to integrate helpful developments without losing the benefits of diversity or making the environment for innovation unstable. Now, of course, fragmentation is endemic to international law. It's not unique to intellectual property law. And a set of integrative tools have evolved to control it. Unfortunately, most of the approaches that may work in other areas of intellectual property law don't seem to work terribly well that work for other areas of international law don't seem to work terribly well for intellectual property law. So one, of course, is the most favored nation clause. There's an MFN clause in the TRIPS agreement, but significantly, this is the first time in multilateral intellectual property agreements that we've seen an MFN clause. Why hasn't it been used before? Because MFN doesn't actually work very well for intellectual property. I could go on and on about why that is, but I think it's sufficient to say this is the most favored nation clause, right? Intellectual property is not a favor to all nations. Some of them would rather not have higher levels of intellectual property. Then there's the Vienna Convention on the Law of Treaties. So Article 31.3 instructs decision makers to take account of all relevant international rules, quote, applicable to the relations between the parties. And the Koskamieni report of the International Law Commission, which is sort of the principal report on fragmentation issues, relies extensively on this tool for avoiding cycling and incoherence. But there are many reasons why this tool doesn't work very well, for international law in general, for intellectual property in particular. So one is there are a couple of cases of the GSB that seem to indicate that this isn't going to work very well. One example is the EC Biotech case, where a WTO panel interpreted between the parties to mean the entire WTO, not the parties to the dispute. These new intellectual property regimes have too much of a variable membership to make effective use of that strategy. And we can talk about other fragmentation tools in the Q&A. But for right now, what I'll say is that none of these tools work very well. And so we suggest a different approach, what we call integration through interpretation, which relies on the idea found in Article 31.1 of the Vienna Convention that terms in a treaty are to be interpreted contextually and in light of the instrument's object and purpose. Under this view, Articles 7 and 8 would take center stage. They'd allow panels to be more open to normative considerations when there's a textual basis in these provisions, and more willing to consider the motivations underlying state actions when they resonate with the objectives of TRIPS. WTO adjudicators could also situate terms contextually by consulting the other instruments produced through regime shifting. However, use, in our view, would depend on three sets of variables. First, the source of the instrument, including the expertise of the body that promulgated it. Second, the governance of that body, how much participation went into the development of the instrument. And third, the relationship between the measure and the TRIPS agreement. So WIPO initiatives actually form the best case scenario. The source here is impeccable. WIPO's expertise comes from decades of administering almost all of the other international IP instruments around the world. There's about 25 of them. The governance of WIPO is also fairly participatory. Hard law requires consensus, and many soft law instruments are also based on widespread agreement. Furthermore, many WIPO agreements have a strong relationship to TRIPS in that they clarify rights or adapt them to new technological environments. Now, that doesn't mean that everything that WIPO does we would regard as part of interpreting TRIPS, but there are some things that would. So one of the things that WIPO does in that joint recommendation on well-known marks is define the term well-known, which isn't in the TRIPS agreement. So we think there's an expert body that's interpreted something, good to use that interpretation. On the other hand, that joint recommendation also adds this new right of dilution, which doesn't seem to be in TRIPS, and there was, in fact, a very divisive meeting about it, and a couple of countries that dissented on the record, so we would not incorporate that into TRIPS. So WIPO, though, is still the best case. ACTA and the TPP, on the other hand, present a rather different situation. So on the one hand, they too could be seen as clarifying TRIPS. So ACTA's enforcement provisions correct what many perceive to be faults in the DSB's China enforcement case. But the negotiations for ACTA were largely conducted by trade hands, so there's little claim to expertise. And much more important, governance leaves much to be desired. The negotiations were entirely done in secret. Their drafts were confidential, and most annoying to me, selected players in the creative industry received copies of drafts along the way, but public regarding NGOs did not. So we'd see their use in TRIPS interpretation as entirely illegitimate. Now that's a hard line, and of course it will perpetuate cycling and fragmentation, which is what we're trying to avoid. But taking that hard line would, we think, have an important side effect. The DSB is the main enforcer in this area, and if it were to incorporate only norms developed through good governance, you might see better governance. NYU has a big program on global administrative law, so anybody from NYU always has to have a little global administrative law in any talk they give. So that's my bit. But at the end of the day, we doubt this approach will be enough to end the cacophony that is so detrimental to innovation. The demandeurs are uniquely incessant. We've become a knowledge economy, and everyone wants in on the action. the matchup between the demandors on the one hand, and Jerry, that's your term, what's the opposite? Resistors, the people on the other side, are persistently asymmetric, with right holders much more organized and better positioned to influence negotiations than the people who are trying to resist higher levels of protection. And because these negotiations take place mostly in a trade context, the negotiators are often so focused on the balance of payments, they may not fully appreciate the need for balance amongst users and producers. Furthermore, the secrecy of many of these negotiations means that negotiators are largely shielded from information that they need to hear. There's an additional problem. International intellectual property law has long been devoted to creating rights. Exceptions are largely framed as merely permissible, and as exceptions, not as the rights of right holders. That structure has several ramifications, or not as the rights of users, I should say. That structure has several ramifications. Legislatures obliged to execute international commitments focus on what they must do, and the permissive exemptions sometimes fall by the wayside. In many legal systems, rights are construed expansively, but exceptions are interpreted narrowly. So users get less than they need and producers more than they deserve. Because the rationale for exceptions is poorly articulated, international adjudicators have little to rely on when deciding whether particular national legislation is allowable. And given the unpredictability of outcomes, states become less willing to safeguard access interests because they don't want to get hauled before the WTO, where they might lose. The agreements, in effect, enhance the leverage of those asking for stronger protection and diminish the clout of anyone who's opposed. So my co-author and I end the book with a proposal for an international intellectual property acquis. We draw the idea of an acquis from European Union and WTO law. So both bodies recognize that in addition to the specific measures set out in their constitutive instruments, there's an underlying body of principles, and these principles are part of the regime even though unexpressed. They further legitimate expectations, they fill gaps, and they create certainty and predictability. Articulating an acquis for intellectual property would, we think, likewise make explicit the structure of the intellectual property system as a whole. So we look to copyright, patent, trademark, and so forth, examining not only the express provisions of international instruments, but also principles that appear repeatedly in national laws, that undergird long-standing national practices, that are embedded in cognate bodies of law, and which are reflected in national constitutions. These multi-sourced equivalent norms, to use a term coined by Tomer Brody and Yuval Shany, demonstrate a consensus among lawmakers, and recognizing their existence would, as with the EU and WTO acquis, further legitimate expectations, fill gaps, and promote certainty and predictability. Now, the acquis as a whole would include principles protecting those who develop intellectual property, so the creative industries, and state interests as well. But the acquis' major significance would be to bring to the fore principles that protect the consumers of intellectual materials and those who use them to push the frontiers of knowledge outward. So I'll end by illustrating how we build that part of the acquis. So looking at intellectual property laws holistically, we see three kinds of strategies to safeguard user interest. First, subject matter exclusions. So even the major conventions recognize that some absolute exclusions are necessary. TRIPS, for example, provides that copyright protection shall not extend to ideas, procedures, methods of operation, or mathematical concept as such. National courts don't often interpret international agreements, but a few have, and they suggest that these provisions function as ceilings on national protection. National legislation is even clearer about the notion that some advances, even if they're new to the storehouse of knowledge, can't be protected. Ideas and facts, terms that uniquely describe a good or a service, principles of nature, products of nature, abstract ideas, and mathematical methods. Together, these provisions suggest that the basic building blocks of creativity, the fundamental components of expression, elements essential to vigorous competition must remain in the public domain. Second, every international property regime includes a series of limitations on protection. For example, the Berne Convention includes a mandatory quotation rights, a set of specific exemptions for teaching and reporting. TRIPS permits states to revoke trademarks when they lose distinctiveness, to issue compulsory patent licenses to meet local needs, to protect health, safety, and nutrition, to prevent one patent from blocking the exploitation of another, and it allows judges to take the public interest into account in framing remedies. Both agreements also include general exceptions clauses. Again, national laws are similar. They limit the term of intellectual property rights. In the United States, for example, that limit is a constitutional requirement. They permit private uses, research uses, interoperability uses. The First Amendment in the U.S., human rights and moral concerns have informed decisions of U.S., Canadian, U.K., and EU courts. So what are the broader principles we can garner from these? Even when works are protected, there are important social uses that should not be in the control of rights holders. Rights must be read in ways that permit others to live a fully creative life, to adapt works, tinker with them, individuate them, satisfy their own intellectual inclinations. Intellectual property rights don't exist in a vacuum. Other commitments and constitutive values limit the strength of the protective regime. There's also a lesson in the structure of these measures. Some are open-ended in order to accommodate unforeseeable social and technological change. Finally, there are laws aimed at controlling abuse. Some within intellectual property law, like copyright and patent misuse, others outside it, like antitrust law. Nations recognize that intellectual property rights don't just encourage innovation, they could also be deployed to protect incumbents from innovation, and that both private and state involvement is necessary to maintain a robust creative environment. So we think an acquis of this sort would have many advantages in intellectual property law. Explicit recognition of user interest would provide states with guidelines on what is possible in light of their international obligations. Recognition would, moreover, add normative heft to pro-access arguments. And a key would put access interests and safeguards on a level with the protection afforded to rights holders. More generally, an acquis would offer adjudicators a better handle on all sides of the intellectual property equation and facilitate dispute resolution. As Robert Hudak has argued, the DSB seems to shrink from normative judgments in order to protect its legitimacy. But implementing views shared by the intellectual property community as a whole is hardly illegitimate. With an acquis, the DSB could act less like a bunch of accountants and more like true adjudicators. More important, an acquis would create a legal framework for structuring future international lawmaking and hopefully bring about a more coherent set of international rules which would benefit the current generation of producers, successive generations of producers, as well as those who wish to benefit from the world's creative efforts. Now, our vision of an acquis is not meant to be definitive. Rather, we hope that others in the IP community will help join us in fleshing out its provisions of what might be considered the ius cogens of innovation law. And again, I gave you the example of user rights. We think it should also include producer rights and the rights of the state in the intellectual property realm. So thank you very much.
David first.
Am I calling on David?
Yeah, sure.
I'll call on David.
You're okay with it?
I'll call on David.
Well, you began your lecture by talking about the necessity to cede a certain amount of sovereignty. And then toward the end of the lecture, you mentioned the First Amendment and limitations on terms. And, of course, I'm completely in accord with those thoughts. But the reality seems to me to be that insofar as what you're proposing is concerned, it's not likely to be more effective in the end than 30 years worth of efforts in this country alone to persuade decision makers to take the public domain into account and to give it an affirmative status, which is, I think, pretty much what it is you're proposing. And to do it within just weeks after Golan versus Holder has been decided, in which it seems to me that if you read Justice Ginsburg's opinion, you see not only that the First Amendment is really essentially a null set in the calculus of rights on the part of users, but that even what one might have supposed for many decades to be at least some bedrock principles under the copyright laws, term limits, for example, which disappeared as a serious matter in 2003, and now the idea of the public domain is a kind of sacrosanct place, from which it now seems that Justice Ginsburg says, if Congress really wants to do it, it can withdraw things that have already run their full term of copyright and put them back out of the public domain. I look at those things and I really wonder what it is that can be done. Now, I'm not in the least unsympathetic to your book, but it does strike me that something more may be required. And then I think about what happened on the very day when Golan versus Holder was decided, January 18th, which was the day that Google and Wikipedia shut down the internet or came close to doing that. And I really can't help wondering if the future of international law lies not in one kind of accord or another, but rather in the fact that pirate bays will spring up around the world and flourish to the point at which, in order to deal with them as a continuing problem, some of these things will have to be approached in an entirely different way. That's a proposition that I'd like to hear your response.
Okay, well, there's a few things there. So one is about Golan against Holder. So Golan against Holder sort of, I mean, to me, the most annoying part is that where Justice Ginsburg says that people don't have a reliance interest in the public domain. The public domain is just detritus, and there's no right to rely on something being there, so you can just take stuff out. Yeah, so, one thing I'd say about that is, the big elephant in the Golan against Holder room was the question of whether or not by treaty you could avoid limitations in the Constitution. And everybody was sitting and waiting for that part of the case. And all of this was necessary in order to avoid asking whether the executive's power under Article 2 trumps the limitations on Congress in Article 1. They didn't want to go there, and so they wrote a totally outrageous opinion. And, I have to wonder whether under other circumstances they would really say the same thing. The second thing I'd say that Golan against Holder shows, and, it's not polite to say this about Justice Ginsburg for reasons we all know, but I think it tends to show sort of a lack of an appreciation of the structure of the intellectual property system. And that's the thing we're fighting about, is the notion that that rights of right holders are trumps and the user's interests are just they're not rights. They're simply the absence of rights of right holders. We're just living in, sort of the leftover space that right holders haven't colonized yet. And so then the question becomes, how do we change that? So, we being lawyers want to change it with, some law-like thing. So, I don't want to change it with another written instrument because it's not going to get adopted, and if it is, it'll be ignored. So I want to change it by sort of creating a kind of ius cogens. I mean, we know that a country can't pass a law that, you can kill anybody you feel like. You'd say that's just against the law of nations. So we'd like to do that, to create some notion of there is actually a law of nations about users' ability to be creative and to live a creative life. The second way of doing it is the way that activists do it. So, marching, shutting down the internet, these are good too. But I don't think they're mutually exclusive of one another. I think they help each other. But I think all of this is a reaction to exactly the same thing, that you just can't write these rules that just commodify everything. And you might just say these are mean, terrible people who know what they're doing, or you can say these are people who just really don't get what the system is actually supposed to look like. And I prefer to think the second. Larry?
So
On the acquis proposal specifically, so I like the idea that you have a set of core principles that you kind of keep referring back to, and that they're balanced and they have all of the different elements that you mentioned. But I want to sort of think about how you operationalize it. If this is primarily a set of background principles that WTO adjudicators use, then I'm a little bit worried because the number of TRIPS dispute settlement cases, right, is kind of fallen off.
Well, we may be seeing some more, right?
There may
be an India 3D case coming.
Yeah. So we'll see. We'll see. I mean, we'll see.
Yeah.
But so one question is, sort of, who are the decision makers? You could imagine that since you're talking about an acquis in the European Union system, the acquis applies to national judges. It applies to the European Court of Justice. It applies, to national regulators, or should apply to national regulators as well. So it could be a common enterprise, right? But then if that's true, then I'm worried a little bit about the details, because I get that, let's say we all agree on the principles. It's the specific applications in different contexts that is contested. Your kind of fair and balanced, or appropriate kind of construction of users is somebody else's unreasonable exploitation. So, and then you might have disagreements, right? If it's a decentralized acquis that's being applied by groups of actors around the world. So the bottom line is, how do you operationalize the acquis principle?
Well, I think of it in the way that the European Union is the acquis. It's not really, specific things that say, mashups are okay, but, taking too much is wrong. It's more a question of understanding that you need to have certain things that are available to everybody in order to promote their creativity. And I think that would help. I mean, if you just look at the WTO cases we've had until now, you look at the Section 110.5 case, which I just taught. I mean, it's clear the adjudicators did not have a clue about what it was that people were seeking to promote. And if you look at that case, too, they talk about the Berne acquis. So there's a whole section on the Berne acquis and what it includes. And then they move on to Article 13 of the TRIPS agreement, and you can't even see what the relationship is between those two things. I mean, I say to the students, this case in the casebook has been edited, but not the transition between the discussion of minor exceptions doctrine and Article 13. So there's really no clue that there are a set of background rules that informed the way that people constructed the Berne Convention or constructed the TRIPS agreement. So, the bottom line on that opinion is it's entirely ahistoric. They didn't notice that the Berne Convention's exceptions clause was only about the reproduction right and not about everything else. They didn't seem to notice that it was written in a flexible way because different countries had different views on what the actual kinds of things that ought to be in the public domain, publicly accessible, I shouldn't say in the public domain, and which things shouldn't be. And I don't think you're going to be able to reach agreement on those things, but you need to reach agreement on the notion that there are some things that people are going to need in every country in order to further their own creative impulses. And so I want the acquis to be basically broad and not really narrow. And I think the more adjudication you get over it get with it in national courts and regional courts and stuff, the more it will flesh out. And if other people start writing about it, it will flesh out more too. So, we looked at some of the things like Bernd Hugenholz and Ruth Okediji want to create a specific set of exceptions and limitations. I don't think that's going to work because I don't think people are going to agree to the specific ones they put out. I'd rather have general principles about what it is that the intellectual enterprise requires. And that's, acquis might not be the right word, but we went through about 10 of them, and that was the one when we had to turn in the manuscript that it still said. So that's the word we've chosen. Andrew?
I've got 3, and they may be easy, so you might be able to say yes, no, maybe, like that. But first one is, do you then, with the Neofederalist vision, adopt, does it require and support a broad reading of the 3-factor test? So in other words, the Max Planck version of the 3-factor test instead of the 3-step test that we
Well, yeah. In fact, I'll answer them in order because I'll forget the first one by the time we get to the third one. So, yeah, I do on the whole agree with the Max Planck proposal of actually changing the TRIPS agreement. I mean, first of all, I certainly agree with the notion that the three-step test should not be decided. If you flunk the first step, you don't go on to the second or third. I mean, just that. I mean, just the idea that that's the way you would interpret the three-step test shows you that there's an entire misunderstanding of what it is that intellectual property law does. So for those of you who are students, the three-step test says that an exception has to be limited. It has to not interfere with normal exploitation of the work, and it has to not unreasonably prejudice the interests of the right holders. And the patent one also says taking into account the interests of third parties. So the patent one sort of makes explicit that you are weighing the interests of right holders against the interests of other people. So if you're talking about a health-related thing like pharmaceuticals, you'd be interested in the interests of the patients in being able to get access to pharmaceuticals. So the provision actually kind of makes explicit that you're balancing interests. But by doing this cumulatively, by first asking, is this a limited exception? And saying, well, if it's not a limited exception, we don't go any further, then you never take the interests of users into account. It just never happens. So, or if you look at the Article 13, the one for copyright, it doesn't explicitly say take the interests of third parties into account, but it says special cases, which you might interpret it as meaning special to the country, part of their cultural requirements, their scientific heritage. But they didn't do that either. They said special means limited. Well, if they're giving every word a different interpretation, that's an odd move. And of course, it, again, totally eliminates the ability to think about a balance of interests. So, just getting across the idea that there needs to be a balance, I think, is important. And the Max Planck thing does a lot of that balancing. I mean, they put it much more explicitly into the agreement.
So then I'll go to my third question. It seems to me you're making an argument, make international intellectual property law look like common law and not like civil law, and that a lot of your problem with, for instance, adjudication is that it looks like these kind of civil law, incredibly narrow readings of things. And then, then my question is, is this possible without re-educating,
Well, I point you to the ECJ, or the CJEU, right, the Court of Justice of the European Union, which certainly started with a civil law bent, and I think has become more common law-y as it's gone along. Why is that? It's because it's trying to create law that seems legitimate to, 27 different countries, all of whom had different traditions beforehand, and the only way that you can do that is by taking things as if they were general principles and interpreting them in a way that's sensitive to what's the underlying policy. And so, to the extent the CJEU has become more common law-y, I think the same would be true of the DSB. But I don't think that being civil law is the DSB's only problem. So one of these TRIPS cases, Robert Hudek was actually on the panel. I mean, he was on, I think it was the 110.5 case, was it? I can't remember. I mean, he's a guy who's written extensively about the way to think about the GATT. And, he's criticized panels before in the GATT for being too literalistic, for failing to take into account, what's underlying what the state has actually done, for looking only literally at the meaning of terms rather than looking more holistically about what the terms are supposed to be signifying. And then he goes and does it in his own case. Why does that happen? I think it partly happens for the reason he said when he was talking about GATT cases, that there's this terrible fear of appearing illegitimate, of appearing to be activist, of appearing to be judgmental. Normative judgment looks activist or judgmental, and so they try to avoid that by instead sticking to the specific terms of the agreements. Now, in his own articles, he sort of hints that you can't keep a system going that way. It's just not going to work. Why did he do it when he gets on a panel and is interpreting the TRIPS agreement? I think it's partly because they actually have no normative vision. I mean, they have nothing to rely on. They just don't know this area of the law well enough. It's not been subject to dispute resolution before, and so we don't have international dispute resolution documents that show what it means. And so they go off. So then the Doha Declaration gets decided. And the Doha Declaration actually says things like, look at Article 7 and 8, interpret the agreement in light of Article 7 and 8, exactly what the Canada Pharmaceuticals case said you can't do. So, I think the thing is just not going to work. We're just going to move on to other regimes unless you can get more of a handle on what it is that intellectual property law is supposed to do. So that's 1 and 3. Did 2 get subsumed into?
2 was the question I expected Larry to ask. So where does international human rights law fit into this?
Yeah.
If it's not going to compel the TRIPS dispute resolution panels, how does it fit into the Neofederalist vision? I mean, it's clearly going to take things in a particular direction.
Yeah, well, I mean, as I said, I would use other instruments as interpretively, and that would include human rights regimes. And the problem with human rights regimes, read Larry's stuff, it also seems to promote the interests of right holders. So it's not clear how it's. I think you're wrong in thinking that it's only going to be on the user side. It too would be more balanced. Jerry?
Well, I think that there's some hooks that your approach could latch on to that could give it more power than one might thought. I mean, you have to be careful. Andrew put his finger on first part I was going to say, keys can work both ways, right? So the Europeans could say, well, the 3 affirmative answers to the 3-step test, that's a key around the world. Isn't that what everybody said? So that could become a key under the principles of the Section 110.5 case. We'll pass over that. That's more.
I don't know. I think the 110.5 case has been more heavily criticized than you suggest.
No, I know, but
yeah.
But I just point out that the word "a key" itself is a little dangerous, but the idea behind it I like a lot, and that's that you're trying to find general principles of intellectual property law, and that's recognized already in the sources of law, general principles of law. So why don't we find out what these general principles of law really are? And the fact that the appellate body, not in the IP cases, but in some very recent trade cases, has suddenly awakened to the fact that the Vienna Convention says you must interpret in the light of objectives and principles, and we will hold you to that from now on. This suggests a major shift. This suggests that the approach of the 110 of the Canadian that's right, that would have been wrong. Mm-hmm. That would have been reversed. You would have had to use it. So it seems to me, and now that you have this WIPO development agenda, which is very amorphous, it seems to me that that is also something that the WIPO development agenda could actually and fruitfully do. Because just talking about the public domain gets you nowhere. But talking about underlying general principles of intellectual property law is recognized by all nations under the ICJ. That might work, and that might give you a kind of, take the worst case. You don't get agreement, okay, because that's likely. You're not going to. So then you get what? Well, you look at your soft law declaration on famous marks, right? So there are lots of brackets, and different countries can take different brackets. However, all the options were really there. You can't say that anything was left out of that declaration in the bracketed form. You say, well, pick the one that works best for you, but that's a big step beyond where we were before. And I think you could get a bracketed set of general principles of intellectual property law in that context.
I like an unwritten constitution better than a written one in this respect, but I mean, if you look at the development agenda and what's gone on with the development agenda, they've sort of separated everything out into 42 different committees or something, or they're not 42, 12 or 13. They're each doing a tiny little piece of something or other. They don't seem to be working coherently together. So I'm not expecting a huge amount from that. But we have sent the book to Francis Gurry, so.
There's a new development. They're having this economic analysis of 5 specific areas with a lot of people who normally are not talking to WIPO.
Well, we'll see what happens. Yeah. I mean, I think that would be a great place to start. Yeah.
Another question or comment? You're all just waiting to buy the book.
Yeah, right.
Well, that will just give us a little extra time. You may have some comments or questions afterward, but please join me in thanking Professor Rochelle Dreyfus.
Thank you.
Produced by Duke University. Online at duke.edu.